This is Barry Zalma on insurance, and today I'd like to speak about some tests for determining the duty to defend under a third-party liability policy. In many states, that type of determination requires application of what is called the four corners or eight corners rule. This is a rule of interpretation of the duty to defend a liability claim. Many states apply a rule of interpretation of the duty to defend a liability claim by limiting their review to the facts alleged in the lawsuit and the wording of the insurance policy. They refuse to consider any evidence extrinsic to the allegations of the suit. If any of the allegations are potentially covered by the policy, the duty to defend is established. If none of the allegations in the complaint is potentially covered by the policy, the insurer can usually refuse to defend. Four corners refers to the parameters of the policy. There is a variant test known as the eight-corner rule. There is little difference between the two. They both take into consideration the four corners of the suit and the four corners of the policy. Courts operating under the four corners or eight corners rule will not consider extrinsic facts or the potential for a suit drafted out of spite. The prudent insurer will, before making a decision, determine what rule or test is applied in the jurisdictions where the loss occurred. The rationale between the two rules is to require insurers to defend their insureds against all covered claims, regardless of merit, allowing an insurer to admit extrinsic evidence that contradicts a plaintiff's allegations to establish the applicability of a policy exclusion would circumvent the very reason for the rules. Many jurisdictions have ruled that any doubt regarding the obligation to defend is to be resolved in favor of the insured. The obligation to defend is measured by the terms of the policy and the allegations of the complaint against the insured, and where the complaint reveals potential liability within the policy. The duty to defend arises if there is a doubt as to whether the insurer must defend. The doubt should be resolved in the insured's favor. In Lennox Construction versus Selective Way Insurance Company, a 2018 decision of the Third Circuit Court of Appeal, Lennox Construction, Inc. appealed a summary judgment in favor of Selective Way Insurance Company on Lennox's declaratory judgment action for insurance coverage. The district court held that Selective had no duty to defend or indemnify Lennox in state court litigation that arose out of problems experienced by a condominium development in South Philadelphia, Pennsylvania, applying the law of that state. The dispute underlying this coverage action began between the Villas at Packer Park Condominium Association and various entities collectively referred to as Westrum. Westrum was hired as the general contractor for the 92-unit development, and it subcontracted with Lennox to perform rough and finish carpentry and to install paneling, windows, and doors provided by the developer. Upon completion of the project, it was discovered that some units experienced water infiltration, leaks, and cracked drywall. The Villas sued Westrum in the Philadelphia County Court, alleging contract and warranty claims. Westrum impleaded Lennox and others, asserting claims for breach of contract and indemnification. Soon after it had been joined as a defendant, Lennox notified its insurer, Selective, of the claim, stating that the commercial general liability policy in effect when the defects were discovered entitled Lennox to defense and indemnification. Selective initially denied Lennox's request, but eventually agreed to defend Lennox subject to a reservation of rights. In response to Selective's reservation of rights letter, Lennox filed an action in the Court of Common Pleas seeking a declaration that Selective was obliged to defend and indemnify Lennox. After Selective removed the action to federal court, the parties filed cross motions for summary judgment regarding Selective's duty to defend, and Selective also filed a motion for summary judgment on its duty to indemnify. For its part, Lennox sought reimbursement for fees that had occurred in the time period between its demand for a defense and Selective's agreement to provide one. The district court concluded that the allegations against Lennox were not covered under its CGL policy, so Selective had no duty to defend or indemnify Lennox. An insurer's duty to defend and indemnify is determined solely in a four-corner state like Pennsylvania from the language of the complaint against the insured. In this case, Lennox CGL policy insured it against bodily injury and property damage caused by an occurrence, which an endorsement to the policy defined as an accident, including continuous or repeated exposure to substantially the same general harmful conditions. Lennox contended that the pleadings established occurrences under Pennsylvania law in three ways. 1. Damage occurred to areas of the property on which Lennox did not work. 2. The damage was caused by work performed by other subcontractors. And 3. The damage was caused by defects in the materials that Lennox used rather than by its own faulty workmanship. Selective countered that Lennox liability arose from its own faulty workmanship, which is not covered as an occurrence under the policy. Selective countered that Lennox liability arose from its own faulty workmanship, which is not covered as an occurrence under the policy. Lennox pointed out to extrinsic evidence to support this argument because the pleadings do not contain allegations sufficient to support a claim that the windows, doors, and/or panels used by Lennox actively malfunctioned, directly and proximately causing the property damage to the project. His argument failed. Coverage would have been found if the plaintiff alleged that the windows, doors, and/or panels actively malfunctioned. It did not. Lennox received no coverage for defense or indemnity. Many states, on the other hand, allow extrinsic evidence to allow a court to fairly determine the duty to defend. Pennsylvania does not, and contractors like Lennox will lose coverage it should be entitled to unless the law is changed. The California Court of Appeal in George F. Hildebrand v. Insurance Company of North America, a 2002 decision of the California Court of Appeal, explained that California has moved away from the Four Corners rule to include extrinsic evidence in the evaluation of the duty, in order to prevail on the issue of the duty to defend. The insured must prove the existence of a potential for coverage, while the insurer must establish the absence of any such potential. In other words, the insured need only show that the underlying claim may fall within policy coverage. The insurer must prove it cannot. Facts merely tending to show that the claim is not covered or may not be covered but are insufficient to eliminate the possibility that resultant damages or the nature of the action will fall within the scope of coverage, therefore add no weight to the scales. The insurer is not required to indemnify the insured if the potentiality of an accidental cause never materializes. If the jury finds that the insured intentionally caused the plaintiff's injury, or if the insured is convicted of the crime of battery or assault. However, even though a policy excludes liability arising from violations of law, there is the potentiality that the jury would find there was no violation of law and that the policy provided coverage. However, if the claims of negligence against the insured were potentially covered under the policy, the insurer will still have a duty to defend. Determining whether insurance coverage exists requires analysis of the claims asserted in the state court action. In Virginia Electric versus Northbrook, a 2007 decision of the District Court for the Eastern District of Virginia, the court noted that Virginia recognizes the potentiality rule, wherein an insurer's duty to defend is triggered if there is any possibility that a judgment against the insured will be covered under the insurance policy. The 8 corners rule compares the 4 corners of the insurance policy with the 4 corners of the underlying complaint to determine whether coverage exists. A duty to defend in such circumstances was found in CNA versus Seaboard Surety, a 1986 decision of the California Court of Appeal and its progeny. Likewise, the insurer may produce undisputed extrinsic evidence that eliminates the possibility of coverage, as stated in Montrose Chemical versus Superior Court and Armstrong World Industries versus Aetna. The most egregious application of the potentiality concept, in my opinion, was the California Supreme Court finding in Clemmer versus Hartford, a 1978 decision that found that a wrongful death suit, even though the insured had been tried for first-degree murder and convicted of second-degree murder, still required the insurer to defend the killer to the wrongful death suit. The case arose after the insured, Dr. Lovelace, placed a pistol in a shoebox, took it to his car, and drove across the street from his apartment to the gas station. He then left the car and, carrying the gun, approached Dr. Clemmer. He greeted Dr. Clemmer and then shot him twice. These shots were followed by 2 more shots. Finally, Dr. Lovelace knelt close to the victim and at close range shot him in the head. The gun was placed on the ground. Dr. Lovelace remarked that he knew what he was doing and that Dr. Clemmer was destroying him professionally. The Supreme Court reasoned that there was a potentiality that the jury would find there was no intent on the part of Dr. Lovelace to kill, and concluded, quote, "It is clear, however, that this argument not only ignores the specific language of the instruction, which speaks in terms of intent to shoot and harm, not in terms of intent to kill, but refuses to recognize the clear line of authority in this state to the effect that even an act which is intentional or willful within the meaning of traditional tort principles will not exonerate the insurer from liability under Insurance Code Section 533 unless it was done with a preconceived intent and design to inflict injury." It's difficult for me to understand how you could claim there was no preconceived design to inflict injury when a person lies in wait and then shoots his victim 5 times, the last being a coup de grace by shooting him in the head. Of course, he claimed he didn't mean to hurt him after shooting him 5 times, but applying the law, the court granted a defense. Amazing to me, and it's still the law in California. If the person insured fails to give notice of a loss, but rather pays to defend himself, the insurer is not required to pay any fees incurred before the tender of the defense to the insurer. The wise insured will, of course, immediately report all liability claims to the insurer to avoid a denial of defense costs paid before the tender. The wise insurer will assert its rights under the no voluntary payments clause of the policy immediately to avoid claims of waiver. This video was adapted from my book, Zelma on Insurance Claims, Part 105, 3rd edition, and is available as a Kindle book, a paperback, and as a hardcover from Amazon.com. If you found this video to be interesting or useful to your colleagues, please pass it on, and please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can learn of future videos. And also, please click on the like button or the Rumble button when you view the video to allow the publishers or conveyors of these videos to know that you appreciated the video. Thank you for your attention.